Well, hello and welcome. Disability Law Show. John Scholes here and James Fireman. Welcome to another 30 minutes of disability law knowledge coming right at you. You can reach out anytime during the show or afterwards. 1-855-821-5900. help@disabilityrights.ca is the email address, and anytime go to the website, disabilityrights.ca. Amongst other things there, you will find links to our long-running radio shows as well, pretty much coast to coast, so you can tune into those at your leisure whenever you have a station in your market. James, lots of stuff to get through today, including 3 things that must be in your doctor's report to strengthen your LTD application and claim. That is on the way. Trust me, that and some of your emails, and we'll go to mydisabilityquestions.com and get to some questions from that website as well. But James, first, a success story, a week that was, something that's been happening on your end for the last week. What's going on, pal?
Well, so I wanted to talk about a case that we recently were able to resolve at mediation. And usually when I'm talking about my success stories, oftentimes it's a fairly adversarial process where we think about the case very differently than the insurance company, and we butt heads a bit, and then we come to some agreement where we're all able to accept it, and we move on from there. So this is a situation that was a little bit different. It was a creative solution to a problem, and it's something that both sides wound up being very happy with. So I had a client who was working for their employer for more than 25 years and really enjoyed their employment, but became disabled, both a physical and psychological disability, and had been off for some amount of time. And the employer was self-insuring, which means that the employer is the one who is paying the benefits if approved. But they rely on another company to do the administration. So they're not the ones who are, the employer wasn't the one who was looking at all the medical documents. They hire another company, and in this case, it was one of the larger insurance companies, to adjudicate the claim. So this insurance company would accept all the medical documents, review it, and provide their opinion. And if the insurance company said that she was disabled, they pay. If they said no, then they don't. And so what had happened here is the insurance company had gone through the documents, and although they had paid for a certain amount of time, eventually cut her off, saying that she was no longer disabled. So it wasn't really the employer's decision that had led to her being cut off the benefits, but they're the ones that are ultimately paying. And so when we brought the legal claim, we named both the employer, who's the one who has to ultimately pay, as well as the insurance company that was providing the adjudication, the administration of the file. And I was expecting to have something of an adversarial process, even though my client, in the interim, after having been cut off, had started to improve. Not to the point where she's 100% better, but to the point where she really was thinking about when she might be able to return to work at some point, hopefully in the reasonably near future. I knew it was going to be a different mediation almost right at the start, when the lawyer for the employer started by saying how much they really valued my client's services, and how much she was, and how positive the reviews were from her supervisors and managers in her department. And that was just an unusual thing to hear. Usually we're quite positional when we get to a mediation, and so you don't get that sort of a concession from someone sitting on the other side. And so when we went into our separate rooms, I had a long conversation with my client about what she wanted to achieve, and she told me that ultimately what she would really like to do is to be able to go back to work. And that's, if that's what my client wants, then it's my job to do whatever possible to get that resolution for my client. And I'm happy to report that after a very long negotiation, we were able to get a resolution where her employer paid her 100% of the benefits that she should have been paid from the point where she was cut off up until the point of the mediation. And we worked out a plan for her to gradually return to work in a few months down the road, where she's going to have accommodations, and it's going to be a setup that's going to allow her the best possibility to succeed when she does feel ready to return.
In your experience, is that the more common scenario, as opposed to the insurance company being the one who pays for the benefit and adjudicates the claim, or when there's two separate? Did that make a difference, you think, in this case, or just lucky?
I think it made a huge difference in this case. When you see it happen, when you see an employer being the one who pays benefits, usually it's a circumstance where you have a very large institutional type of employer. So think of like large multinational companies, banks often are set up like this, when you have someone who is large enough that no particular insurance claim is a risk to them one way or the other, it usually financially makes sense for them to be paying the benefits themselves so that they don't have to pay out the premiums to a separate insurance company. And then they hire someone with expertise in adjudicating disability claims to help with managing the files. And that way you also don't have to share personal information with your employer.
You know, you toss around the term mediation there all the time, and I think it's worth mentioning. A lot of people think if they bring a claim about and they're off work and they're trying to get disability from their insurance company, it's going to go to court, and there's going to be judges and juries and all kinds of scary things. But that's not the case, is it?
No, it's really not, especially not in long-term disability world. So if you bring a claim for long-term disability benefits and you're cut off and we have to bring a legal claim, that does not by any means suggest that you're going to wind up in court in front of a judge. That is exceedingly rare. What happens the vast majority of the time is we're able to resolve cases at a mediation, which is typically about 8 to 10 months after we're retained to represent the client. The mediation itself is quite informal. There's no judge there. The person who is in charge, so to speak, is called a mediator, and they're just an impartial third party that both sides agree to beforehand to help facilitate a settlement. But it isn't something that has a large amount of structure where there's a ton of different rules or where anything that happens if you don't resolve is binding. That's one of the great things about mediation. If it doesn't resolve, nothing that happens during the mediation can be used down the road. So it allows everybody to talk very freely during the mediation.
I want to take a moment to mention a very informative and useful website for you to use anytime called pocketemploymentlawyer.ca. As the title would suggest, it's about employment law, and sure, there's enough about employment law on the website. There's also a section on disability law. Why? Because there's a ton of crossover, as James just alluded to in his Week That Was story, where the employers and the insurance companies and disability, so on and so forth, they're bound together. So there's a section on disability law for you to glean from the website, pocketemploymentlawyer.ca. Absolutely free. Absolutely anonymous. You can get smart and then click your browser off. Nobody knows you were ever there. Again, pocketemploymentlawyer.ca. But James, I did mention off the top of the show, disabilityrights.ca is our website, and there you can find a radio station in a market near you where you can catch our radio show. We get a lot of good calls on the show. You answer a lot of questions when we're on air over that hour, and we'd like to take some of the good phone calls, play them back here, and talk about them a little bit. So for this week, I want to get to our first call from our radio show right now.
I have spinal stenosis and fibromyalgia. In the report my doctor put together, he said that my condition is from moderate to severe. Now, I tried to put through a claim to my work-term disability. They didn't approve it, and then I appealed 2 more times, and they turned it down. I see a specialist, but because of COVID, everything's been shut down. So because I have not been diagnosed by this doctor, they will not give term disability.
So that's a very difficult situation. Now, when you apply for disability benefits, there is no requirement that your claim is supported by a specialist. So the insurance company can't say, oh, well, you don't have a specialist and therefore you are 100% not entitled to benefits. But they're likely going to try and take that position anyway, even though that's not something they're allowed to do in the policy. And so it becomes a question of what are you able to get? And so obviously in this particular situation, the caller here is in a difficult spot. He can't get to see the specialist because of COVID, and he's relying on his GP's evidence. Here's the thing. What is not required in order to have a successful long-term disability claim is a specific diagnosis. There's nothing in the policy that says you need to have this diagnosis or that diagnosis in order to be approved. What's required is that you have a disability that prevents you from doing your job. And when courts have looked at it, the way they interpret that is you have to have symptoms that create functional limitations that are preventing you from being able to do your own occupation. So if that is your situation, you should be approved. So what do you do in this situation if your insurance company cuts you off because you can't get to see a specialist because of COVID? Well, typically what I'm going to say is you want to bring a legal claim. You want to fight them on it right away. This is one unique scenario where, depending on the circumstances, it might, I'm going to caution you here, it might make sense to wait and appeal, but only if you are going to get to see that specialist in a reasonably short amount of time. Because if you do that and you do get to go see the specialist, let's say you have an appointment 1 or 2 months from now, that specialist might be enough in those circumstances to get the insurer to change their mind. I doubt it, but it's possible, and it's worth taking a shot. I wouldn't wait 6 months for it. If it's going to take 6 months to see the specialist, start the claim now, because by the time you get to see the specialist, you're going to be pretty close to resolution on the legal claim anyway. So it doesn't make sense to wait a long period of time, but this might be one of the very rare exceptions where if you have an appointment with a treating specialist in the near future, it might make sense to wait till you hear from that specialist, provide that to your insurance company, and give them an opportunity to respond. Even if they don't reinstate you, even if they don't change their mind on the appeal, you've still put yourself in a better position, because now they can't down the road say, oh, well, we didn't have this information. We were justified at the time. Had we known, we would have approved you. Now you've given them that opportunity. They no longer have that argument. So again, I'm going to caution you. It is a very narrow exception, but it is a possibility that it might make sense in that situation too.
You also said something interesting there as well, that to trigger your benefits, it's based on symptom, not diagnosis. A lot of people don't know that.
Yeah, that's true. That's something that comes from the Supreme Court of Canada.
Right.
The analysis is focused on your symptoms, not the diagnosis. There's no requirement in the policy for a diagnosis. If there is, it's a very unusual policy. Typically, you see that sort of thing in critical illness policies, where if you have one of 10 or 12 enumerated diagnoses, you're entitled to a lump sum payment. Long-term disability and short-term disability policies are very different in that regard. The analysis is on your ability to function in the workplace. And if you have symptoms, whatever the diagnosis is, if you have symptoms that are creating a functional limitation that is preventing you from doing your occupation, then you're entitled to get your long-term disability benefits.
Coming up here, short break, and we'll get into 3 things that must be in your doctor's report to strengthen your LTD claim. Okay? An application. We'll get to that after a short break. 1-855-821-5900 to reach James and his crew anytime. Disability Law Show, stick around. We are coming right back. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, welcome back. Thanks for sticking with us. John Scholes, James Fireman there as well. Reaching out is simple. help@disabilityrights.ca through email. And the website disabilityrights.ca is there for you anytime. And inside the website, lots of information, lots of contact, and links to our radio show as well. But James, let's get to this. 3 things that must be in your doctor's report to strengthen your LTD application. And here we go, and your claim for that matter. Number 1 is this: an explanation of your illness or injury and how they affect your ability to work.
Sure, and going back to what I was talking about in the earlier segment in the show, you don't specifically need to have a diagnosis. Now, if there is one, it certainly does help to clarify things. But even in the absence of a diagnosis, what's really important is that there's information in that report that outlines in some detail what your functional limitations are. So how do your disabilities or disabilities impact your ability to do things, to do your occupation? And so things that we're looking for: your ability to sit, your ability to stand, your ability to walk, your ability to lift heavy items. Those are all things that may be very relevant depending on what your occupation is. Even if you have a sedentary job is going to require you to sit for extended periods of time. And if you have a disability that prevents you from being able to sit for more than 30 to 40 minutes, there really isn't a scenario, unless you have significant improvement, that you're going to be able to work full time. even if you're able to sit and stand, how often are you going to be able to do that if you start getting pain after 30 or 40 minutes? You might be able to do that 2 or 3 times in any given day and get through that with increasing pain as the day goes on. But are you going to be able to do that for 8 hours a day, for 5 days a week, for 250 working days in a year? I don't think so. So it's important that your doctor is really specific about what your functional limitations are, and try and relate those functional limitations to what would be required in your job. Now, we don't expect doctors who are providing this information to insurance companies to be vocational experts, so you might need to help them. If you don't have a job that is reasonably self-explanatory, it might be useful to let your doctor know what is required of your job, or better yet, provide them with a job description if one is readily available, so that they can take your functional limitations and apply them directly to the job, to your occupation, when they write that report you're providing to your insurance company.
All right, second thing that's got to be in that report is confirmation that you are following prescribed treatments.
Yeah, so you have a duty in your policy to mitigate. And really what that means is that you have to take reasonable steps to get any treatment that is available to you. So it could be therapy, it could be medications, it could be any number of different things that your doctor is suggesting, and you have a duty to make sure that you are adhering to that treatment plan. And so you want to make sure that your doctor has outlined what that treatment has been, and that you have been adhering to it, that you've been following the guidance there. And if there has been any point in that, in your recovery, where you haven't strictly followed, that there's an explanation for that. Now, one little side note I want to talk about here is where surgery is suggested or even recommended. Can the insurance company use the fact that you've decided not to get recommended surgery against you? Usually, I mean, they may try and do it, but usually courts are going to find that they're not justified in doing so, because surgery comes with usually a significant amount of risk. Now, there are some surgeries that are relatively routine and low risk, and an insurance company that cut you off if you refuse that type of low-risk surgery might be justified. But any surgery that is somewhere beyond that, any surgery where there is any kind of risk that you might have a serious disability resulting from the surgery, or even possibly death, which is always a possibility anytime you have to go under, if that is something that is concerning you and you refuse to have surgery as a result, it is not something the insurance company can and should be relying upon to deny your benefits. Anything else, any other treatment or any other medication that's been recommended by your treating doctors, that you should be doing. You should be adhering to all of that.
Let me add a little sidebar to what you mentioned before about recommended treatment by your doctor. What if it's their doctor recommending the treatment you have to use?
You know, John, I would have been disappointed if you hadn't asked me that. I almost purposely left that
coming,
there
right?
for you. I knew that you were going to ask me that. So you're quite right in bringing that question up. If it's something from the insurance company,
right,
they're suggesting that you get this other type of treatment, you can't simply ignore it, but you should run that by your own doctors. If your own doctors are telling you that, yeah, that's actually not a bad idea, well, now it's been recommended by your doctors too, so you better get it. But if your doctors are telling you that it's not necessary, or even worse yet, that it might in fact be harmful, then you should not be doing it. Your treatment is obviously a very important medical decision that you should be making with doctors that you trust and rely on, your own treating doctors, not doctors that are paid for by an insurance company that has an obvious interest that is in conflict with your interests. The insurance company just wants to get you back to work. Yep. They're not concerned with your long-term health. Your own doctors are. So you listen to your own doctors whenever there's a conflict between what they are saying and what the insurance company or even the doctors from the insurance company are telling you.
Okay, third thing that has to be in that doctor's report is that you are unable to work for the foreseeable future. How about that?
Yeah, so prognoses are never certain. No one has a crystal ball. Even if it's relatively short term, there's a certain amount of guesswork. So it isn't really necessary that your doctor be able to say that this person is going to be better in 3 weeks or 6 months or 2 years. That's not what's required. Now, if there is a pretty good timeline, by all means, your doctor should feel free to share it. But if your doctor isn't sure, then they should indicate that, and better yet, they should indicate why they're not sure. Is it because you still need to see a specialist, or you need to have a certain type of x-ray or some other sort of test that a specialist might administer? If so, then indicate that the doctor should indicate that the referral to that specialist has been made, or you've been booked to have the MRI or the CAT scan or whatever it is that you need, and that's happening on such and such a date. And if it's none of those things, if it's just a case where you have a disability that is not predictable, where it's something that you don't know how long into the future it's going to impact you, then your doctor should at the very least indicate what the timeline is for follow-up. So say you're likely going to be disabled for at least the next 3 months or whatever they feel comfortable with, and that you will follow up at that point in time and provide an update. As long as the insurance company has that, there's no basis for them to reject that note and say that it's up in the air and that it's too uncertain. If the doctor is saying, yes, we're continuing to treat, we're continuing to follow this patient, and this is what our plan is, that ought to satisfy the insurance company. And if it doesn't, they're not in a good position to argue it if you were to bring a legal claim down the road.
All right, coming up here after a short break, what happens when pressure to return to work leads to a relapse? We'll tackle that after the break. 1-855-821-5900, help@disabilityrights.ca for email as well. Lots more coming up. Stick around. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. Hi there, thanks for hanging around. Disability Law Show, a few minutes to go, so let's get right back into it. I mentioned this website off the top of the show, James, and we're going to refer to now. That is mydisabilityquestions.com. Absolutely free and anonymous for you to use. There's a searchable database, so maybe the question you're about to type in has been asked and answered. It'd be good if it was. If it's not, leave it there. James or a member of his team will get to it. And one for today comes from our pal Malachi. Says 18 months into a disability claim for chronic anxiety and depression, my caseworker is stressing me out about doing their recommended programs for a return to work. I have my own therapists and have been attending sessions. A contract position did come up for 6 months with very minimal requirements compared to my previous job. What will happen to my benefits if I relapse while trying this contract position?
So that's a really good question, and I think a lot of it's going to depend on whether or not you decide to go through the program that your insurance company is recommending. You can refuse to do that, and if you're planning on returning to work, then it doesn't matter as long as you're able to successfully return to work. In other words, if your insurance company isn't happy about what led up to you returning to work, but they pay you your benefits up to that point in time, who cares? But Malachi is asking a good question because he's asking what happens if I relapse. So just to step back for a moment, if you are getting long-term disability benefits and you attempt to return to work and you're not successful, in most cases, your policy is going to have what we call a recurrence provision. And that is in there for that specific circumstance. You attempt to go back to work, and within a certain amount of time, usually it's 6 months, you find that you're not able to actually successfully return and you have to go back on disability. The recurrence provision is there so that you don't have to go through another elimination period. When you start the claim, you usually have to wait 3 to 6 months before you start actually getting paid your benefits. So if you attempt to go back to work after you're getting benefits, you would invoke the recurrence provision, you would skip the elimination period, and presumably you would start getting your benefits again, in theory. Now, here's the issue. if you do attempt to go back to work, if Malachi attempts to go back to work and doesn't go through the insurer's recommended return to work program, whatever it is that they have, whatever it is that they think is going to be useful, whether or not it is an entirely separate question. If you've refused that assistance and you attempt to go back to work and you're not successful, I guarantee you the insurance company is going to say, had you gone through our program, you would have succeeded, or at the very least, you would have been more likely to succeed. Leave aside whether or not that's true, you've just created a really good argument for them. So I'm not telling you have to go through their program, but if you're concerned about a relapse, take a look at what the program involves, ask your doctor whether or not what the program offers is going to be useful, or at least if it's going to hurt you. As long as your doctor isn't telling you that going through that program is going to be harmful, then why not? If you're able to do it, it puts you in a better position if you do have a relapse when you try to go back to work.
help@disabilityrights.ca. That is the email. Anytime, use it. Nazine is up next. James says, I've just filed a claim for long-term disability. I'm well aware that the insurance company may put me under surveillance to find a way to deny my claim. Do they actually have a right to invade my privacy? I have nothing to hide, but I also don't want them to infringe upon my rights and add to my stress.
Okay. We have to really slow down here. Surveillance is something that people put far too much weight on. It's something that weighs on people an awful lot, and it really shouldn't. It's something that is pretty rare. I don't see surveillance on most of my files. When there is surveillance, it's rarer still that surveillance is of any value to the insurance company. As long as you have a legitimate disability that is preventing you from going back to your occupation, then if you're being truthful with your insurance company, then there's nothing that you need to hide. Just like Nazine has mentioned here, there is nothing that you need to be concerned about. If you are following your doctor's recommendation, if you're going to the treatments you're supposed to, if you're not engaging in activities that you're not able to do or that you say you're not able to do, what is surveillance going to turn up? Who cares what they find if everything is well within what you've already told your insurance company is your situation and what is completely outlined in your medical file? What difference does this surveillance make? None at all. And in fact, what I usually find when there is surveillance is it's far more likely to be helpful to my clients. Because you have this investigator following around my client for 4 or 5 days, 60 hours, often 70 hours, something like that, and they find nothing. And if they followed you around for that duration of time and haven't come up with anything concrete that undermines that you are disabled, that just reinforces that you in fact are. That's probably the best evidence that you're disabled, that they've hired an investigator and weren't able to turn anything up. So usually it winds up backfiring. But to get to the heart of it, any concern that you have, they're not allowed to invade your privacy. They can't come into your home. They can't intimidate you in any way or bully you. And good private investigators, professional private investigators, know that, they understand that, and they're trying to keep a low profile. The last thing they want is for you to know that they're there. If you're aware that someone's following you around, that's obviously going to change your behavior. So it isn't something that is likely to be an issue. If it is, and you're at all concerned, I would recommend calling the police. If you have someone following you around, even if you suspect it might be an investigator, unless they're wearing a sign that says, I am a private investigator hired by your insurance company, you don't know who they are. So call the police and report them and make sure that it's not someone who is up to no good or who might pose a threat to you or your family.
And lastly, I know we got to go, but I imagine it's so expensive that they're going to try to get something out of it.
Yeah, they will, and it's not uncommon if they've hired an investigator for surveillance for them to take whatever they find and use anything they can out of context.
Yeah.
And they'll try and cherry pick this or that. They'll say that you went to the drive-through 3 times or whatever as evidence that you're physically capable. It's usually meaningless, and I wouldn't let them intimidate you into thinking that because they have surveillance, all of a sudden your case has changed. If you have been honest with your insurance company and you're legitimately disabled, it simply can't be the case.
And that is the way we are going to wrap for today. Some final contact, 1-855-821-5900, help@disabilityrights.ca, the email, the website, disabilityrights.ca as well. And while you're there, you can find a radio show that we host near you as well. We'll catch you next time on the Disability Law Show. Thank you so much. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca.